Medical Termination of Pregnancy Act of 1971, MTP Act 1971, acts as an exception to which section of the IPC and in what way? Now, this is a subjective type question. We are talking here of exceptions to IPC. It is not necessary that an amendment has to be made only in the IPC to cause a variation. If a provision is made in some other act and that act provides that the provision made in that act supersede the provisions of IPC, that will also amount to an exception. So, the MTP Act of 1971 acts as an exception to which section of IPC? Yes. The relevant section is section 312. Section 312 says whoever voluntarily causes a woman with child to miscarry shall be punished if such miscarriage be not caused in good faith for saving life of the woman. Causing miscarriage is permissible under section 312 only on the ground of saving the life of the woman concerned. That is the only ground on which miscarriage can be caused. That of course should be done in good faith, but the only ground on which it can be done is saving the life of the woman. Now, the MTP Act of 1971 extended the scope of legally causing a miscarriage, and now there are more than one grounds on which miscarriage can be caused. So, I'll just show you the relevant provisions which act as an exception to this section, section 312 of the IPC. Section 312 says miscarriage can be caused only on one ground, but these grounds have been now extended. We'll see how. That is one thing. If the ground of saving the life of the woman is available, then miscarriage can be caused by anyone and at any place. As far as section 312 is concerned, it lays down no restrictions regarding the place at which miscarriage can be caused. It also lays down no restriction regarding the person who can cause this miscarriage. If the ground of saving of the life is available, only one ground is available, no further restrictions. And also there is no restriction as to by what period of pregnancy, at what stage of pregnancy, or rather up to what stage of pregnancy miscarriage can be caused. That limitation or restriction is also not there in section 312. Now we come to MTP Act. Section 3 of the MTP Act says, notwithstanding anything in IPC. So this section opens with this phrase, non obstante clause, notwithstanding anything in IPC, which means that now this provision which follows overrides the provisions of IPC, which means again that it is an exception to the concerned provision of IPC. And it says, a registered medical practitioner shall not be guilty of any offense under IPC or any other law if any pregnancy is terminated by him in accordance with the provisions of this Act. So this section of the MTP Act permits a registered medical practitioner to cause miscarriage in accordance with the provisions of this Act, to terminate a pregnancy in accordance with the provisions of this Act. If he does so, it will not be an offense under section 312 of IPC. So now the provisions which now follow are an exception. What are the provisions? The second subsection says a pregnancy may be terminated by a registered medical practitioner where the length of the pregnancy does not exceed 12 weeks if such medical practitioner forms the following opinion in good faith. So the first part says that if the pregnancy is only up to 12 weeks, then an RMP can terminate that pregnancy if he forms the following opinion. The time period here is up to 12 weeks. The second provision says that if the time period has crossed the limit of 12 weeks, but still it has not exceeded 20 weeks, then also this subsection permits termination of the pregnancy provided there are two RMPs who hold the same opinion. And now we will see what opinion is required to be held by them. This is the time period or the stage of pregnancy up to which termination is permissible by law. 12 weeks with the opinion of one RMP, up to 20 weeks with the opinion of 2 or more RMPs. Now, what are the grounds on which pregnancy can be terminated? This is the first ground. Continuance of the pregnancy. If continuance of the pregnancy would involve a risk to the life of the pregnant woman, which essentially means that a pregnancy can be terminated to save the life of the pregnant woman. And you will notice that this ground is the same as the ground given in section 312 of the IPC. So as far as this is concerned, it does not add anything. That ground is there in IPC also, this ground is there in MTP Act also. But now the second ground. If continuance of the pregnancy would involve a grave injury to her physical or mental health, this ground is not there in 312. A new ground has been added. Pregnancy can be terminated if its continuance is likely to cause grave injury to the physical or mental health of the pregnant woman. This is a new ground. Also, there is one more ground which is in this slide. There is a substantial risk that if the child were born, it would suffer from such physical or mental abnormalities as to be seriously handicapped. So now we are talking of the physical or mental health of the child also. This provision was not there in section 312. Under 312, a pregnancy cannot be terminated on the ground that the continuance of pregnancy would cause physical or mental abnormalities to the child. It was also not permissible there to cause termination on the ground of grave injury to the physical or mental health of the pregnant woman. So these two grounds have been added. These two grounds, along with the first ground, saving the life of the woman. So now in total, we have 3 grounds on which pregnancy can be terminated. Of course, it is only up to the stage of 20 weeks of pregnancy. That is one thing. Then next, no pregnancy of a woman who has not attained the age of 18 years or who is a lunatic shall be terminated except with consent in writing of her guardian. If a pregnancy has to be terminated under the MTP Act, then consent of the guardian, in case the woman is under 18 years of age or a lunatic, or her own consent if she is not falling in that exception, consent is required. No such consent is required in 312, but here it is required. And what else? Section 4. No termination of pregnancy shall be made in accordance with this act at any place other than a hospital established or maintained by government or a place approved for the purpose of this act by government. So only at an approved place a pregnancy can be terminated under this act, under the MTP Act. Only in a hospital. So a pregnancy cannot be terminated at the home of the lady. It has to be done at a hospital. This is the requirement of section 4. And then we have this last section, section 5. Notwithstanding anything in IPC. So this is again clearly a notwithstanding clause, a non-obstante clause. This acts as an exception to section 312. It says termination of a pregnancy by a person who is not a registered medical practitioner shall be an offence punishable under IPC. Shall be an offence punishable under IPC, and IPC shall stand modified to this extent. So here clearly IPC is being modified not by making a provision in IPC itself, but by making a provision in some other act. In this case, it is the MTP Act. So please remember, the IPC section 312 is being modified by section 5 of the MTP Act in this way. And what is the way? Termination of a pregnancy must be done only by a registered medical practitioner, even under 312. And what are the grounds under 312? There is only one ground, saving the life of the woman. So if we are going strictly by section 312, there is one ground on which termination is permitted. That ground is saving the life of the woman. But now, even that ground will be available only if the termination is done by a registered medical practitioner. If even for saving the life of a woman, termination is done by any other person, it will amount to an offense under 312. That is the effect of section 5 of the MTP Act. Is this clear? So to what extent section 312 has been modified? For saving the life of a woman, termination can be done but only by a registered medical practitioner. MTP Act gives some more grounds on which termination can be made. There are two more grounds: physical or mental health of the woman, physical or mental health of the child. But if we are availing those grounds, then further restrictions are that the termination must be done within 12 weeks or within 20 weeks of the pregnancy. In no case, pregnancy can be terminated beyond 20 weeks of the pregnancy under the MTP Act. Under IPC, there is no such restriction, which means if the ground is saving the life of the woman, then even if termination is done beyond 20 weeks, it will not be an offense under section 312, provided it is done by a registered medical practitioner. But if it is to be done on the ground of mental or physical health of the lady or of the child, then MTP Act will apply, and in that case the time limit will also apply. It cannot be done beyond 20 weeks of pregnancy. Next, if termination is being done on the ground of saving the life of the woman, then of course it has to be done only by a registered medical practitioner, but it need not necessarily be done in a hospital. Section 4 will apply only if termination is done under the MTP Act. If termination is being done under section 312, there is no requirement of place in that section, and there is no non-obstante clause here in section 4. Therefore, if termination of a pregnancy is done by a registered medical practitioner on the ground of saving the life of the woman, it can be done at any place. The requirement of it being done only in a hospital will not be applicable. This will be applicable only if it is being done under the MTP Act, that is on the ground of the mental or physical health of the woman or of the child.